Hello everyone. Good evening, Ranjana. I hope you're doing well. I welcome you all on LegalEdge After College YouTube channel. So today in this session, we will be discussing multiple choice questions from the case laws. At the same time, जहाँ पे जरूरत पड़ेगी, I'll be discussing the case laws and उन case laws में क्या held हुआ था that as well. All right. So जल्दी से सारे लोग join कर लो. Hi Alisha. Hello. So first question on your screen says a judgment of the Honorable Supreme Court of the 11 judge bench is delivered by, good evening Satyam, delivered by a split verdict of 6:5. Subsequently, a 9 judge bench unanimously takes the view that was taken by the 5 judges in the minority, which judgment will be considered binding. Now, you have to answer this question. Let me explain you the same first. Here it is saying that Supreme Court ने की एक 11 जज बेंच ने एक वर्डिक्ट दिया जो कि वर्डिक्ट जो आया दैट वाज इन 6:5. ऑलराइट, 6:5. नाउ subsequently what happened is 9 जज बेंच ने, ठीक है, यूनानिमसली एक व्यू लिया, ठीक है, that was taken by 5 judges in the minority. Now understand what they are trying to convey here. यहाँ पे total judges की bench जो है वो है 11, right? And later जो total judges हैं वो है 9. लेकिन यहाँ पे 5 का जो था ना that was minority, ठीक है, बट यहाँ पे इट इज यूनानिमस, मतलब 9 के 9 जजेस जो हैं वो मेजोरिटी में है. नाउ यू हैव टू डिसाइड व्हाट शुड बी द करेक्ट आंसर हियर. And if anyone knows the case law from where I picked this particular question, then do mention the case law as well, because this particular question is from a case law of year 2022 only. I'll be telling you, I'll be covering the case law as well. All right. So everyone is saying B should be the correct answer, where uh, the judgment delivered by the majority of judges in 11 judgments should be considered as binding. All right. Anyone knows the name of the case from where this has been taken, or recently in the year 2022, in which case this particular point was discussed? Yes, Charu. Yes, Chinmay. Yes, Prapti. Everyone is right. Whosoever is saying that uh, Trimurthy. So this case was Trimurthy Fragrance Private Limited versus Government of NCT of Delhi. ठीक है, Government of NCT of Delhi. It is 2022 judgment. All right. Yes, yes. So now let's move forward and see question number 2. Uh, Karun Roy is saying, good evening. Your classes are really great. It's helpful and very well taken. Thank you for your effort. Thank you so much for joining. So you people keeps me motivated, and you people keep me taking the class this late, I would say, and bringing the most important relevant content for you. All right. All right. Now, here there are 4 options, right? You have to choose the incorrect law. All right, you have to choose the incorrect law out of these 4 options. First option here says the principle of stare decisis operates both vertically in the sense that decisions of appellate courts in the superior in the vertical hierarchy bind tribunals and courts lower in the hierarchy, and horizontally in the sense that a larger bench is excuse me. I'm so sorry. I'm so sorry. All right. Um, it was in the sense that a larger bench formation ruling would be binding and prevailing upon the ruling of a smaller bench formation. The logic in this stems from the doctrine of precedence, that is stability in law. Now you have to decide कि out of these four options कौन सा option incorrect होगा. All right. Second option here says the law laid down by the Supreme Court in a decision delivered by a bench of larger strength is binding on any subsequent bench of lesser strength or co-equal strength. All right. Now, option C here says that law laid down by the Supreme Court in a decision delivered by the bench of larger strength is binding on any subsequent bench of lesser strength, but not on a bench of co-equal strength. Option D here says a bench of lesser quorum cannot disagree or dissent from the view of the law taken by a bench of larger quorum. In case of doubt, all that of the bench of a lesser quorum can do is to invite the attention of the Chief Justice and request for the matter to be placed for hearing before a bench of larger quorum, then the bench whose decision has come up for consideration. Now, I hope चारों ऑप्शन आपको समझ आ रहे होंगे और आपको ये भी समझ आ रहा होगा कि यहाँ पे जो चारों ऑप्शंस हैं वो कहीं ना कहीं जो त्रिमूर्ति फ्रेगनेंस प्राइवेट लिमिटेड का केस था उसमें जो डिस्कशन हुआ था उससे लिए हुए हैं. Now, what according to you should be the correct answer here? Now, meanwhile, uh, you write the correct answer in the chat box, and meanwhile, let me read the comments here. Soumya, ma'am, your videos are great. I love them. Ma'am, please make a video on split judgment telling what happens after it and the procedure and other things. All right, we will consider it. But Soumya, I would advise you, I would request you rather to drop a comment regarding this in the comment box of any video so that that's somewhere recorded and I can take a call on the same. And Parki is saying, will you revise every subject in 3 days, 9 hours program? We won't be able to revise every subject, but we are trying to make it as relevant, as helpful as possible uh, for you. All right, for CLAT PG 2023. All right, now I believe I have reverted all the comments here, and so many of you is answering that according to you, C is going to be the incorrect option. All right, C is going to be the incorrect option. Why? Why? Because here it is written not a bench of co-equal strength. Okay. However, if you will see, then option number B and option number C, they both are similar. The only difference here is that in option number B, they are saying that on any subsequent bench of lesser strength or co-equal strength, which is correct. However, यहाँ पे क्योंकि not add कर दिया गया है, that makes option number C as incorrect option. All right. So I believe ये समझ आ गया होगा. एंड ये जो चारों प्रिंसिपल यहाँ लेट डाउन है, ये तीन चीजें जो हैं इसको एक बार फिर से पढ़ लेना, बिकॉज पॉसिबिलिटी है दैट क्लैट पीजी इज गोइंग टू आस्क यू अ क्वेश्चन फ्रॉम दीज प्रोविजंस. ऑलराइट, नाउ okay, next question here is as per Article 145, Clause 3 of the Constitution of India, the minimum number of judges who are to sit for the purpose of hearing any reference by the President of India under Article 143 of the Constitution shall be so 3, 5, 7. Such number as the Chief Justice of India may specify. What according to you should be the correct answer here? And if you do like the video, if you do think that these videos are helping you in any manner in your upcoming A-Let or CLAT PG examination, just press the like button. That keeps me running, that keeps me moving. All right. So people are saying it should be B. All right. Now I'm asking another question related with the same only, that which article of the Constitution of India deals with the same or talks about the bench should include 5 judges. Kindly mention the article in the chat box now. Okay. Pooja, how come C? Where have you read that it should be 7? Jayant, where have you read that such members as the Chief Justice of India may specify? You have to open your barrack once again. You have to open your barrack once again and you have to go on Article number 145, the article is there mentioned in the question only. You have to go on article number 145 clause 3, where yes, Prapti, the article was given in the question itself, right? Now, यहाँ पे होता क्या है? So, the minimum number of judges who are to sit for the purpose of deciding any case involving a substantial question of law, all right? Any case involving substantial question of law as to the interpretation of this constitution or for the purpose of hearing any reference under article 143 shall be 5. So article 145 clause 3 दो बातें कहता है. एक बात जो यहाँ पे लिखी हुई है, when case goes via precedent for the reference, and another is whenever there's a question related to substantial question of law, ठीक है, to the interpretation of constitution. All right, so I think आपको क्लियर हो गया है. Shristi, how come D? It should be B. The correct answer here is B, that is 5. All right. Now, right now, 48 students are live, but I have received only 27 likes. Why so? All right. Next question here is, a judgment of Supreme Court is delivered by the split majority of 2:1. इट कैन बी ओवररूल्ड बाय. ठीक है, तो यहाँ पे क्वेश्चन कह रहा है कि एक स्प्लिट मेजोरिटी की जजमेंट है, 2:1 की जजमेंट है. ठीक है, अब वो किससे ओवररूल हो पाएगी? ठीक है, ऑप्शन 1 हियर इज सेइंग सब्सिक्वेंट 3 जज बेंच ओपिनियन यूनानिमसली, and option 2 is saying a 5 judge bench. So according to you, what is the correct answer? Only one, only two, both 1 and 2, none of above is correct. All right. So you're saying B should be the correct answer. What about others? Sahil B, Abhinav B, Ayush B. Yes, you all are right, because it can be overruled only by 5 judge bench. All right, it can only be overruled by 5 judge bench, not by 3 judge bench. All right, okay, 3 तो यहाँ पे भी थे, right? Now, next question here is Article 144A. All right. Article 144A was inserted in the Constitution by 42nd Constitutional Amendment with effect from 0102, that is 1st of February 1977. The amendment read as, excuse me for a minute. Exams are on head and I don't want to fall ill right now. So as you people are always in my life, I'm sharing this that I'm on the verge of falling ill, but I don't want to, as ALET is on 11th and CLAT is on 18th. Hmm. So the amendment read as special provision as to the disposal of question relating to the constitutional validity of the minimum number of judges of the Supreme Court who shall sit for the purpose of determining any question as to the constitutional validity of any central government or state government shall be 7. All right. Now, 2 here is saying a central law or a state law shall not be declared to be constitutionally valid by the Supreme Court unless a majority of not less than two-thirds of the sitting judge for the purpose of determining the question as to constitutional validity of such law hold. So यहाँ पे जो बता रहा है ना, ये क्या 144A जो कि ऐड हुआ था 42nd अमेंडमेंट से ना, क्वेश्चन ये है कि ये जो 42nd अमेंडमेंट से ऐड हुआ था वो कौन सी अमेंडमेंट से रिमूव कर दिया गया, राइट? Many of you are answering A. Few of you, Abhinav is saying B, Mansi is saying B, Lisa is saying B, 44th Constitutional Amendment 1978. All right. So I hope सबको ये बात पता है कि जो भी 42nd अमेंडमेंट के जो चेंजेस थे उनको 44th कॉन्स्टिट्यूशनल अमेंडमेंट, राइट, सो से चेंज किया गया था. बट दिस पर्टिकुलर थिंग 144A इसको रिमूव किया गया था बाय द वर्च्यू ऑफ 43rd कॉन्स्टिट्यूशनल अमेंडमेंट। ऑलराइट, सो यहाँ पे करेक्ट आंसर इज 43rd। तो जस्ट इस नोशन में मत रहिएगा कि सारी चीजें 44th अमेंडमेंट से रिमूव की गई थी या चेंज की गई थी या जो भी हुआ था उसे करेक्ट किया गया था, तो यही आंसर होगा। नाउ द आर्टिकल वाज रिमूव फ्रॉम द कॉन्स्टिट्यूशन बाय 43rd कॉन्स्टिट्यूशनल अमेंडमेंट 1977। ऑल राइट, नाउ it is also proposed to make special provision to enable the Supreme Court and the High Court to deal with pending cases in the same manner as if the said article had been omitted with effect from the 1st February 1977। All right, now understand one thing, यहाँ पे आंसर है 43rd कॉन्स्टिट्यूशनल अमेंडमेंट, नॉट 42nd, क्योंकि हम किसकी बात कर रहे हैं, 144A के रिमूवल की बात कर रहे हैं। ऑल राइट, नाउ किसी ने इसके पहले आंसर 7 जज बेंच दिया था, तो हो सकता है आपने कभी इस अमेंडमेंट को पढ़ लिया हो तो आपको वो 7 वाले नंबर याद हो। However, in 145, in Article 145, the number of judges to constitute constitutional bench is 5। All right, do not get confused yourself by 7। Now, यहाँ पे let's discuss the case law. All right. So, Trimurthy, Fragrance Private Limited versus Government of NCT of Delhi. ठीक है, 2022 का ये judgment है decided by so it was constitutional 5 judge bench consisting of Justice Indra Banerjee, Hemant Gupta, Suryakant, MM Sundaresh and Sudhanshu Dhulia। ठीक है, now in this particular judgment what so the multiple points were dealt, but the important point I have written here, that is a judgment delivered by a larger bench। All right, जो भी judgment एक larger bench देगी, that is going to be that will prevail irrespective of the number of judges constituting the majority in view of Article 145(5) of the Constitution of India। Concurrence of the majority of the judges at the hearing will be considered as a judgment or opinion of the court। Now understand यहाँ पे कहना क्या चाह रहे हैं ये, कि एक अगर जजमेंट आई है, ठीक है, इफ अ जजमेंट इज देयर, ठीक है, 5 जज बेंच की एक जजमेंट है, ठीक है, एंड उसके बाद एक 4:3 की आई है, ठीक है, या हम इसका एग्जाम्पल और सिंपल ले सकते हैं। द एग्जाम्पल कैन बी दैट जो हमने फर्स्ट क्वेश्चन में पढ़ा था, राइट, 11 जज बेंच है, ठीक है, एंड यहाँ पे 9:2 है, ठीक है, 9:2 है, या 7:4 है, जो भी आप इसको लगा के चलोगे वो है। तो यहाँ पे आपको अगर उसके बाद कोई और एक जजमेंट आती है जहां पे जो रेशियो है, ठीक है, रेशियो जो है वो चेंज हो जाता है और एक यहाँ पे ज्यादा हो जाता है, राइट, देन दैट केस एज वेल जो लार्जर बेंच है, irrespective of the majority and minority opinion, irrespective of the dissenting and assenting opinion, आपको ये नहीं देखना है कि जब ये जो बेंच कॉन्स्टिट्यूट हुई थी यहाँ पे कितने जजेस, फॉर एग्जाम्पल यहाँ पे हम 7 लेके चलते हैं, तो कितने जजेस ऐसे हैं जो इसको असेंट कर रहे थे, कितने माइनॉरिटी में थे, दैट इज नॉट अ कंसिडरेशन। व्हाट इज इन कंसिडरेशन इज कितने जजेस ने उस केस को सुना था, उसे हम बोलते हैं कोरम। ठीक है, कितने जज की कोरम थी। ऑल राइट, सो हायर एंड पे क्या जाएगा, जो जज कोरम को कॉन्स्टिट्यूट करते हैं। ऑल राइट, नाउ यहाँ पे minority of judge at the hearing will be considered as a judgment of the opinion of the court। It is settled that majority decision of a bench of larger strength would prevail। Now, when I say larger strength, तो total overall strength देखी जाएगी। All right, over the decision of a bench of lesser strength, irrespective of number of judges constituting the majority। So you need not to see कि कौन कितनी majority constitute कर रहा है। All right, there are high number of chances कि इस particular case law से या इस पर्टिकुलर टॉपिक के ऑन एंड अराउंड क्लैट पीजी आपसे सवाल पूछे। ऑलराइट, सो इसको एक बार और देख लेना। हाउएवर जो भी इसमें इंपॉर्टेंट पॉइंट्स थे वो हमने यहाँ पे कवर कर लिए हैं। ऑलराइट, नाउ डिफरेंट सेट्स ऑफ क्वेश्चंस आर देयर। पहला यहाँ पे क्वेश्चन कहता है द ग्रुप ऑफ कंपनीज doctrine was expounded in। now group of companies doctrine, ठीक है, कौन से केस में एक्सपाउंड हुआ था? All right, anyone? What should be the answer of this particular question? Again, 50 people are online and I just received 38 likes. So in this class, when actually I'm not feeling very okay, I'm ill, I want 50 likes. If you like the video, if you think the video is helpful, just press the like button. Bha- Bha- Bharat is saying D, Satyam is saying A, Snehal saying D, Prapti is saying A. So what we're talking about? We're talking about group of companies doctrine किसमें expound हुआ था. All right. So this word expound is also important. किसमें discussion हुआ था? That I'm not asking. Like into 50. All right. So I'm asking group of companies doctrine was expounded in which case? Vaishali Aneja is saying A, Satyam is saying A. All right. What about others? Now, anyone will let me know what is the meaning of group of companies doctrine and what are the case laws related to that and what is that one case law which has been decided by Supreme Court related to this doctrine in the year 2022. So this doctrine was established, all right? This doctrine was established in the year 2013 by the case of, or in the case of Churolo Controls India Private Limited versus Severn Trent Water Purification Incorporation. All right. Now, I'm not able to pay for the 3 days. Please look into the issue. All right, all right. Now, the group of companies, you have to drop a email on support at toprankers.com. All right. Drop an email on this email ID. All right. If you need any kind of support or if you need any kind of like concession on your fee. All right. Now, but you have to give the proper proofs. Okay. Now, the group of companies doctrine was expounded in. Now, यहाँ पे many of you got confused because this doctrine was discussed multiple times in multiple cases. However, but it was expounded. Okay. It was expounded in this particular case law of Chirolo Control India Private Limited. And you have to remember this. This is very important. Now, when I say group of companies doctrine, what does it mean? So people are writing, Prapti is writing here, non-signatory to arbitration agreement can be also made a party to arbitration dispute if they are claiming under party. So if you give me just a minute time, I need to make a call to get something for my throat so that we can continue with the class. All right. So yes, Prapti, that is the correct meaning of this particular. Anil, chai de do aap, please. सो यहाँ पे ये जो डॉक्ट्रीन है, ठीक है, ये यही बात करता है. नाउ आपको समझना होगा, ठीक है, कि हुआ क्या था या कहाँ से ये सब कुछ स्टार्ट हुआ. सो when I say group of company doctrine, तो ये स्टार्ट हुआ था, लाइक ये प्रोपाउंड हुआ था, एक्सपाउंड हुआ था, स्टैब्लिश हुआ था इन 2013 चुरोलो कंट्रोल इंडिया प्राइवेट लिमिटेड. ऑल राइट. नाउ यहाँ पे अगर ये हेल्ड हुआ था कि कोई अगर कंपनी है, ठीक है, जो कि नॉन सिग्नेटरी है, वो सिग्नेटरी नहीं है, ठीक है, किसी अग्रीमेंट की, आर्बिट्रेशन अग्रीमेंट की सिग्नेटरी नहीं है, लेकिन अगर वो तीन कंडीशंस फुलफिल कर रही है, तो वो जो आर्बिट्रेशन अग्रीमेंट है, ठीक है, उसकी पार्टी मान ली जाएगी। नाउ व्हाट आर दोस थ्री कंडीशंस हियर? दो, पहला कंडीशन है डायरेक्ट रिलेशनशिप ऑफ सिग्नेटरी विद नो सिग्नेटरी पार्टी। तो दो सिग्नेटरी पार्टीज फॉर एग्जांपल ए एंड बी हैं, ठीक है, तो उनका डायरेक्ट रिलेशनशिप होना जरूरी है। ऑलराइट, नेक्स्ट इज कम्युनिटी ऑफ सब्जेक्ट मैटर, ठीक है, तो उनका कम्युनिटी, सब्जेक्ट मैटर कम्युनिटी सेम होना चाहिए। थर्ड जो वहां पे कंडीशन है दैट इज द अग्रीमेंट मस्ट कंप्राइज ऑफ कॉम्पोजिट ट्रांजेक्शन। अगर ये तीनों चीजें फुलफिल होती हैं, ठीक है, तभी वो ग्रुप ऑफ कंपनीज डॉक्ट्रिन अप्लाई या एप्लीकेबल होगा। ऑलराइट, जैसे प्राप्ति ने यहाँ बताया, दिस डॉक्ट्रिन सेज दैट नॉन सिग्नेटरी टू आर्बिट्रेशन अग्रीमेंट कैन आल्सो बी मेड पार्टी टू द आर्बिट्रेशन अग्रीमेंट। ऑलराइट, इफ they are claiming under party. Now from where this contention started, अगर आप सेक्शन नंबर 8 पढ़ोगे आर्बिट्रेशन एक्ट का, तो वहां पे वर्ड्स लिखे हुए हैं they also includes, the words also includes, party में person claiming under that party आता है। I repeat, party also includes person claiming under that party। Now this person claiming under that party, ठीक है, यहाँ पे उनका ये कहना था कि जो नॉन सिग्नेटरी कंपनीज है वो भी लाइक वो भी पार्ट मानी जाएंगी, वो भी पार्टी मानी जाएंगी, ठीक है, नॉन सिग्नेटरी टू आर्बिट्रेशन अग्रीमेंट जो है वो भी पार्टी मानी जाएंगी, सब्जेक्ट टू, इन दिस पर्टिकुलर केस सुप्रीम कोर्ट ने कहा था सब्जेक्ट टू तीन कंडीशंस का फुलफिल होना जरूरी है। ऑलराइट, आई होप यहां तक जो भी मैंने समझाया है वो आप सबको समझ आ गया है। All right. Now, when you have to see this, you always have to read section 8 of Arbitration Act with section number 45. ठीक है, section number 45, ठीक है। नाउ देयर आर थ्योरीज आल्सो रिलेटेड टू द सेम इशू। जो ये थ्योरीज हैं, ठीक है, वहां पे एक इम्प्लाइड थ्योरी आती है। तो जब ये ग्रुप ऑफ कंपनीज डॉक्ट्रिन बढ़ते गया आगे, ठीक है, और बहुत सारे केसेस आए इस पे, ठीक है, बहुत सारा लंबा डिस्कशन चल रहा है, एंड दैट इज अ रीजन सुप्रीम कोर्ट ने इन 2022 प्रेजेंट केस, जिस केस को हम डिस्कस करने वाले हैं आगे इसी लेक्चर में, उसमें ये कहा कि इस पर्टिकुलर डॉक्ट्रिन को रीलुक करने की जरूरत है, ठीक है, और उसे दूसरी बेंच को रेफर कर दिया गया है, ठीक है। तो ये अपने आप में आर्बिट्रेशन एक्ट में काफी इंपॉर्टेंट टॉपिक बन जाता है वो क्लैट पीजी, बिकॉज काफी टाइम से पहले तो ये डॉक्ट्रिन एक्सपाउंड हुआ था, फिर ये डॉक्ट्रिन काफी टाइम से डिफरेंट केस लॉज में डिस्कस हो रहा था, और उसके बाद लेटर रिसेंटली सुप्रीम कोर्ट ने फाइनली ये कह दिया है कि इसको रीलुक करने की जरूरत है। ऑलराइट, नाउ यहाँ पे कुछ और चीजें भी, कुछ थ्योरीज भी देखी जाती हैं, जैसे कि इम्प्लाइड कंसेंट थ्योरी, ठीक है, कि डिफरेंट केस, तो इस ट्रोलो कंट्रोल इंडिया प्राइवेट लिमिटेड में उन तीन कंडीशंस की बात हुई थी, बट डिफरेंट केस को डिस्कस करते वक्त, इस ग्रुप ऑफ कंपनीज डॉक्ट्रिन को डिस्कस करते वक्त सुप्रीम कोर्ट ने ये भी कहा कि अगर आपको ये बताना है कि जो कंपनीज है ये नॉन सिग्नेटरीज होके भी सिग्नेटरीज मानी जाएंगी, उसके लिए आपको कुछ थ्योरीज को देखना होगा, जैसे कि इम्प्लाइड थ्योरी, ठीक है, या ट्रांसफर ऑफ, इम्प्लाइड थ्योरी का मतलब क्या, ट्रांसफर ऑफ कॉन्ट्रैक्ट, किसी ने अपने कॉन्ट्रैक्ट के लिए किसी और को ट्रांसफर कर रखा है, या एजेंट एंड प्रिंसिपल रिलेशनशिप, या पियर्सिंग ऑफ कॉर्पोरेट वेल। तो ये सारा डिस्कशन डिफरेंट केस लॉज में हुआ है। आई विल बी टेलिंग यू द नेम ऑफ द केस, आप उसको एक बार पढ़ लेना। नाउ यहाँ पे multiple people are saying multiple things, Cox and Kings, and yes, absolutely right, the name of the Cox case, right, of 2022. Please just say the name of the case, which you, yes, I'm telling you the name of the case, just give me a moment. Okay, so name of the case is Cox and Kings Limited versus SAP India Private Limited, SAP India Private Limited, ठीक है, ये 2022 की जजमेंट है, ठीक है। सो इससे हम इसके रेफरेंस में वी आर टॉकिंग, आई होप अभी सबको क्लियर हो गया होगा। It is also said in case that this doctrine is not sustainable in India. Jayant, what happened is जब ये डॉक्ट्रिन आया था तब उस पहले केस में जो जो इशू था दैट वाज रिलेटेड टू फॉरेन आर्बिट्रेशन। लेटर डिफरेंट केस में जब डोमेस्टिक आर्बिट्रेशन, चेरियन वाले केस में जब डोमेस्टिक आर्बिट्रेशन की बात हुई थी, तभी भी सुप्रीम कोर्ट ने इस डॉक्ट्रिन को एप्लीकेबल माना था। ऑलराइट, नाउ we are going to see that. So next question में हम बाकी जो इस केस से रिलेटेड फैक्ट्स हैं उनको डिस्कस करेंगे। नाउ which of the following is true about group of companies doctrine? Now you have to decide it. Okay. First, group of companies doctrines has generally been invoked by courts and tribunals in arbitration to either extend the arbitration agreement or bind a non-signatory affiliate of the contracting party to the arbitration clause. Second, यहाँ पे कहता है where an arbitration agreement is entered into by one of the companies in a group, the other member of the group may be bound by the arbitration agreement if the facts and most including the conduct of the party indicates that the true intention of the parties was to bind the signatories as well as the non-signatories. यहाँ पे three कहता है, ये three है, the group of companies doctrine is akin, akin का मतलब होता है same to principle of agency or implied contract that I have discussed when I was discussing theories, whereby the corporate affiliation among distinct legal entities provide the foundation for the concluding that they are intended to be parties to an agreement, notwithstanding their formal status as non-signatories. Commentators have observed the same distinctions between the group of companies doctrine and the lifting of or piercing wheel, the lifting of wheel concept of companies law, wheel piercing principle. Now you have to decide यहाँ पे क्या correct answer होगा भरत, how come B you're saying जो third point है वो incorrect है? So whosoever is answering C, that means all three points or all three options are true about group of companies doctrine, they are right. तो I hope group of company doctrine जो हमने पढ़ा, ठीक है, और आपने ये सारी चीजें पढ़ी तो अब आपको और अच्छे से क्लियर हो गया होगा, ठीक है। नाउ सो इन कॉक्स एंड किंग्स लिमिटेड वर्सेस सैप इंडिया प्राइवेट लिमिटेड, द ग्रुप ऑफ कंपनीज वाज, ठीक है, ये जो ग्रुप ऑफ कंपनीज लाइक इस पर्टिकुलर केस में क्या हेल्ड हुआ, ठीक है, तो ग्रुप ऑफ कंपनीज डॉक्ट्रिन, यहाँ पे डॉक्ट्रिन होना चाहिए, ग्रुप ऑफ कंपनी डॉक्ट्रिन वाज, क्या वो अफर्म्ड हुआ, ठीक है, या द केस विच लेट डाउन द डॉक्ट्रिन वाज ओवररूल्ड, क्या इस डॉक्ट्रिन को ओवररूल किया गया, या द court further expanded the group of companies doctrine in other branches of law, ठीक है, yeah, the correctness of the doctrine in its application to non-signatories was referred to a larger bench. So I already have mentioned कि इस particular case में इस group of company doctrine was in contention, it was referred to larger bench. All right. No, the answer is D, not B. The correct answer is D, because in this particular case, the doctrine was referred to a larger bench. Yes, Mansi. Yes, Jayant. Now, next case law here is, sorry, next question here is, in which of the following historic case it was for the first time held that company is a separate legal entity having an identity of its own, which is independent and distinct from its members and shareholder? What should be the answer according to you? Barrett versus Enfield, R versus William, Solomon versus Solomon, none of the above. Yes, सबने इस केस को पढ़ा होगा in your law school. It is a historic case, ठीक है? And in this case, it was for the first time held that a company is a separate legal entity having an identity of its own, which is independent and distinct from its members and shareholder. All right. Now, next here is, so next slide talks about 3 days CLAT PG masterclass. All right. So 3 days CLAT PG masterclass होने वाली है on 12th, 13th, and 14th. ठीक है? It is going to be like game changer for all the CLAT PG 2023 aspirants. Do join these classes and you will see that last point में जो चीजें हमने पढ़ रखी हैं उनका इतना स्मूथली रिवीजन कैसे हो पा रहा है, ठीक है, या कैसे रिवीजन हो सकता है, या कैसे एक्सपेक्टेड क्वेश्चंस आएंगे, या बहुत सारे क्वेश्चंस यहाँ पे हम सॉल्व करने वाले हैं, बहुत सारे टिप्स एंड ट्रिक्स के बारे में बात करने वाले हैं, जजमेंट्स के बारे में बात करने वाले हैं. सो if you are appearing, and I believe as you are here, so you are going to appear in CLAT PG 2023 examination, right? You're going to get the link in the description box. You can get yourself enrolled in the same. All right, now, next year is as per the Companies Act 2013, a company may be formed for any lawful purpose by first, seven or more persons where the company to be formed is to be a public company. Second, two or more persons where the company to be formed is to be a private company. Or one person where the company to be formed is to be one person company, that is to say, a private company. Now, you have to decide that which of the above statement is correct here. Yes, it is going to be game changer. Bharat is writing game changer. Uh, Satyam is saying, see, what about others? See, so you're saying that all three statements are correct. Public company के केस में the requirement is seven or more, ठीक है? Private company के केस में the requirement is two or more, ठीक है? And for one person company, now one person company का concept 2013 कंपनीज एक्ट से इंट्रोड्यूस हुआ है. इसके पहले ये कॉन्सेप्ट नहीं हुआ करता था. ऑलराइट, नाउ क्या उसके पहले सिंगल पर्सन कोई कंपनी नहीं बना पाता था? ठीक है, तो ऐसा नहीं था. उसके पहले सोल प्रोप्राइटरशिप हुआ करती थी, राइट, एंड स्टिल सोल प्रोप्राइटरशिप हुआ करती है. नाउ एनीवन विल लेट मी नो व्हाट इज द डिफरेंस बिटवीन वन पर्सन कंपनी एंड सोल proprietorship? Just a one line answer. Difference between one person company and sole proprietorship, which is very important. You should know this. So, uh, yes, C is the correct answer, but now I'm asking that what is the difference between sole proprietorship and one man company? Because one man company was not there prior to 2013 Companies Act, मतलब 1956 का जो एक्ट था, वहां वन मैन कंपनी का कोई या वन पर्सन कंपनी का कोई कॉन्सेप्ट नहीं था. One person company is a body, sole proprietorship is not body. Sahil, uh, Prapti is saying one person company, we actually need two person, one, no. So main difference here is that you all know that when I say company, right, तो यहाँ पे कंपनी में क्या होता है, कंपनी की एक सेपरेट लीगल एंटिटी होती है, ठीक है. व्हेन आई से सेपरेट लीगल एंटिटी, इसका मतलब कि जो कंपनी का मेंबर है, ठीक है, जो कंपनी का, अब सोल में तो एक ही पर्सन होगा तो उसको हम मेंबर बोल सकते हैं, ठीक है, मेंबर है, वो कंपनी से अलग है, ठीक है, मतलब उसकी, that is a different individual and company is a different, company has a different status. All right, limited liability rise. So separate legal entity वाला concept जो one person company में होता है, but sole proprietorship में ऐसा कोई distinction नहीं होता है. जो भी liability sole proprietor की होती है वही कंपनी की होती है. अगर कंपनी अपनी liabilities को fulfill नहीं कर पाती है तो in that case that sole proprietor comes into picture and he has to take care of the same. All right. Yes. Now, next here is which of the following cases dealt with the concept of lifting of corporate wheel? ठीक है, Option 1, State of UP versus Renu Sagar Power Company 1988, landmark judgment है ये. Second is Vodafone International Holding BV versus Union of India and others. Again, this is again a landmark judgment. Now you have to decide one, two, yeah, both of them, yeah, none of the above. What should be the correct answer according to you here? How come B, Sahil? Satyam, you're right. How come B? So, this lifting of corporate wheel was discussed in both of these cases. So, answer is going to be C. All right. Now, Cox versus King, Kings Limited versus Cox and Kings Limited versus SAP India Private Limited को हम discuss कर लेते हैं. Here the quorum was Chief Justice of India N.B. Ramana, the then Chief Justice of India, Justice Suryakant and Justice A.S. Bopanna. ठीक है. And यहाँ पे ये कहा गया था, it was held in this particular case, it was asked to have a relook on companies ग्रुप ऑफ कंपनीज डॉक्ट्रिन. तो ये ग्रुप ऑफ कंपनीज जो डॉक्ट्रिन है इसको रीलुक करने के लिए कहा गया था. देयर इज अ क्लियर नीड फॉर हैविंग अ रीलुक at the doctrinal ingredient concerning the group of companies doctrine. ठीक है. 3 judge bench doubt the decision in Cholo Control India Private Limited. All right. versus 7 Trent Water Purification Incorporation 2013. ठीक है. Now, if you remember जब हमने पहला इस set of question का पहला केस किया था, there हमने देखा था कि ये जो डॉक्ट्रीन है ये एक्सपाउंड, ठीक है, इसी पर्टिकुलर केस में एक्सपाउंड हुआ था. तो इस केस में जो डिसीजन था उसके डिसीजन को इस पर्टिकुलर केस में जजेस ने डाउट करते हुए इस पर्टिकुलर डॉक्ट्रीन को रीलुक करने को कहा और इसको लार्जर बेंच को रेफर किया. Whether the phrase claiming through or under, you remember when I was discussing this first question of this set of questions, then I was saying that कि सेक्शन 8 में जो वर्ड्स हैं क्लेमिंग थ्रू और अंडर, राइट, जब भी आप किसी कॉन्ट्रैक्ट को पढ़ते हो तो वहां पे ये वर्ड्स यूज होते हैं. सेक्शन 8 ऑफ आर्बिट्रेशन एक्ट 1996 में सेक्शन 11 में ये वर्ड्स इंक्लूड है. इस वर्ड इन वर्ड्स की वजह से ही it was held in this particular case that group of companies doctrine applicable होगा और non signatories भी parties माने जाएंगी. Could be interpreted to include the group of companies doctrine whether the group of companies doctrine as expounded by Trollo control case and subsequently judgment are valid in law. Now in this particular case the issue was referred to the larger bench. All right. Now I hope you love the class. ठीक है. Okay, somebody is saying something. Saksham, ma'am, will you do a similar class for English and legal magazine for ALED? Saksham, already Shazmi ma'am has taken the class on English language and she's going to take one more class on 9th. ठीक है. So she will be taking class on English, ठीक है, for English section of ALED PG. So don't worry about it. Now, I hope you like the video, and if you have any doubt, if you have any request, do leave a comment in the comment box. All right. And if you have any doubt related to CLAT and ALET PG 2023 examination, then also your doubts are welcome. आप चाहें तो अभी भी पूछ सकते हैं. आप चाहें तो बाद में comment box में अपने doubts को या इंस्टा पे जो मैसेज बॉक्स होता है आप वहां पे भी प्राइवेटली अपने डाउट्स पोस्ट कर सकते हैं. So, I'm like, so we are ending this session here only, and keep studying. Till then, bye bye. Bhumika and Dori signing off. That was it.